All right, well, it's 2 o'clock, so let's go ahead and get started. Welcome everyone to our latest webinar on the Oregon Realtors Forums. Today, we're going to be focusing in on the manufactured home and floating home sale agreement. One thing I'd like to note is that if you have a question, um, if you could use the Q&A function, that will help me just kind of manage questions and you know, make it clear when I've answered one and when I haven't, because the chat can get kind of crowded sometimes. So appreciate it if you would do that. And feel free to ask any questions that you have. Want to get them answered, and we want this to be valuable for you. And hello. Oh, someone's in Hawaii. That's great. Aloha from Hawaii. All right. We're going to walk through the manufactured home and floating home sale agreement today. But first, I'll give just a brief tour of our website about where you can find additional training materials. I like to start all these presentations with that so that everyone's aware of where they can get those resources. And then, a few additional things that I just want to mention because we're talking about manufactured home and floating home sales today. And that includes the very important fact that you need to have a license to sell a manufactured home in a park. Okay, so if you don't have that, you cannot be doing that. That is a license that's provided through the Department of Consumer and Business Services. It's a separate license from your real estate license, which is with the Oregon Real Estate Agency. And I'll just point you quickly to that law. That is ORS 446. 676 is the, or excuse me, 671. This is the prohibition on selling a manufactured structure without a license. Okay, and it is a criminal penalty. Okay, and so you do not want to do that. You want to avoid that at all costs. So you need to work with the Department of Business and Consumer and Business Services to apply for an application in order to be able to do this kind of a sale. But I do want to point out to you that there are exceptions, and under ORS 446.676, subsection 14, a licensed real estate broker who is acting in the employ of or on behalf of or under the supervision of an individual who is both a licensed principal real estate broker and a licensed manufactured structure dealer does not need to individually have a license. Okay, so if your principal broker or your firm has a license and you're operating under the supervision of the person that has a license, then you would be able to engage in manufactured structure sales that are in a park. Okay, if the manufactured structure is on real property, it's going to be a real property transaction. It's not going to be the form that we're talking about today. It's going to be the residential property form, and you don't need a separate license for that. Your real estate license will cover that. If you want to learn more about manufactured structure dealer licensing and where to get that license and how to go about applying, go to the Department of Consumer and Business Services Manufactured Structure Dealers Licensing page. Okay, I will copy this here and I will drop it in the chat so that you have a link to that. Okay, there you go. And please take time to learn about this licensing process. Okay, as it relates to the floating homes, okay, there is not a separate license that you need to sell a floating home. Okay. The other thing I want to point out is your E&O insurance. Your E&O insurance may or may not cover you for selling a manufactured home in a park. Okay. Your E&O insurance may or may not cover you for a floating home. I think in most cases, it doesn't cover floating home situations. So you really need to check with your E&O insurance as well before you begin engaging in these transactions if that's not something that you've already done. The other thing that is important to know, and for those of you who do a lot of these deals, I'm probably not telling you anything you don't know, but I know that there's a lot of folks getting into manufactured home sales or floating home sales that haven't done that in the past, in part because of affordability issues and the demand that's increasing for those types of homes. But when you're dealing with a sale of a manufactured home in a park, or when you're dealing with the situation of a floating home in a marina, you're both selling that personal property that is the home, okay, whether it's the manufactured home or the floating home, but there's also going to be a lease for the space, okay, whether it's in the manufactured home park or in the marina park. Now, in some instances, those are cooperatively owned by the tenants of the manufactured home park or the marina park, in which case it would be kind of a cooperative ownership situation. But in almost every case, it's a tenancy situation. So your client is not only buying the home, they are going to be entering a tenancy. Okay. And that those tenancies have their own laws associated with them and rules that govern them. And you really need to do your part to get up to speed, to at least have a strong baseline level of knowledge in those things, but then also know who to point your clients to get the expertise that they need. Okay. And you know, you should be pointing your clients to talk to an attorney who deals with landlord and tenant issues related to manufactured home spaces and floating home spaces, because they really need to understand that piece of it as well. And part of the sales process is going to be them reviewing the rules and regulations of the park or the marina, as well as completing an application to become a tenant of that park or marina. And that's just a whole kind of another piece of this. And you don't want to enter into this transaction on behalf of your client if you're not at least familiar with all of that and know where to point your client to get the expertise that they need. Okay. And along with that, your client is going to need to be approved to be a tenant of that manufactured home park or be a tenant of that marina park. Okay, so that's another kind of step in the process, and they're going to have to fill out that application and get that approval. There are different types of inspections that are relevant here. With a manufactured home, you're going to be dealing with some specialty inspections related to sort of structural and foundation issues that a typical home inspector may or may not be terribly familiar with. Okay, perhaps they are, but are going to want to find a home inspector that is used to dealing with manufactured homes and foundation issues related to that. Okay, with a floating home, a float inspection. Okay, not just an inspection of the structure, but a float inspection. So again, being aware that that exists and that's something that's important for your client to do in order to do their due diligence, and then finding out where you can point your client to find those experts. The other thing is we recognize that as more of our members get engaged in these types of transactions, we need to do more education. So we hope today's class on the forum is helpful, but we are certainly thinking about additional classes we can provide related to doing deals related to manufactured homes and parks and floating homes, and trying to identify experts that we can bring in to be able to teach additional classes on these topics. And then final thing I want to point out is that we recognize that these deals are different than residential deals, and to some degree we have mirrored our manufactured home and floating home sale agreement on our residential purchase and sale agreement. And that may mean that there are certain items in it or fields that are a little clunky as it relates to the manufactured home sale or the floating home sale, because those elements were initially designed with residential in mind. And so we recognize that this document is going to improve over time as we get feedback from experts in the field who are using it in practice in these types of transactions. So the form is serviceable, it's usable, it'll accomplish a transaction, but there certainly could be elements where an item that we're going to discuss today is really more relevant for a traditional residential sale than a manufactured home in a park or a floating home in a marina. And I will try to point those out to you and make suggestions to you on how to sort of reduce any clunkiness that might come along with that. So before we pull up the document, I just want to remind everyone where they can get additional training materials on our website. So this is our training tab. Click on training. You will find our training library. You will see a variety of options. We have self-paced trainings, okay? These self-paced trainings include a using Oregon Realtors forms. That's our baseline training on our residential sale agreement. the death of the transaction training, which is about defaults and terminations in our sale agreements, and then navigating tenant occupied properties. We have both an investment property addendum and a tenant vacancy addendum when a buyer is going to be moving into a property that currently has a tenant. That training is on that topic. We have navigating contingencies with Oregon Realtors forms, key differences between OREF and Oregon Realtors forms, and the ins and outs of our client representations agreements. We'll keep adding to these, but just wanted to point those out, are all available to you, self-paced. We have live trainings and webinars, including the one we're doing today. If you click this button here, you will see the upcoming instances of live trainings. Next week, we're doing one, I believe, on our agricultural purchase and sale agreement, so I hope that you check that out. We have our virtual open house that takes place every Friday at 11. We didn't do that today because we had our board meeting, but going forward, it will continue every Friday at 11. You can drop in and just ask whatever questions you have of the attorneys that drafted the form. Myself and Nicholas Peasley, our staff attorney, one of us will be staffing those 11 o'clock Friday open houses. And then we have a series of recorded tutorials as well. They're not for CE credit like the self-paced training and the live trainings are, but there are a series of videos that are generally shorter in nature, but that will provide you with important information. And we have one on lead-based paint, we have one on repairs, and we'll continue to add to that, but we have several in there right now. The other thing I want to point out to you is our guided form library. So we have this including for the manufactured home and floating home purchase and sale agreement. So if you go to this section of our website and you click this button here, it will pull up a version of our form that has little play icons next to each provision. Okay, that starts here. And if you click the play icon, a video will pop up and explain that section of the document. So we do have that for this manufactured and floating home purchase and sale agreement. So feel free to take advantage of that resource. All right. So that is just a quick overview of our training opportunities. Let's now take a look at the manufactured home and floating home sale agreement. Okay. And before I continue, I just want to check to see if there is any Q&A. Nothing at this time. All right. So the first thing we start here is with our final agency acknowledgement. And we do this with all of our documents. Now, we recognize that in a situation here where if there was no real property involved, so you're doing a manufactured home in a park or you are doing a floating home in a marina, then the final agency acknowledgement isn't really required under the Oregon regulations. Okay, that's no REA regulation. And if you're doing a manufactured home in a park or the floating home, you're not really under OREA's jurisdiction. Nevertheless, we think it's important, we think it's a good regulation, and we think it provides useful information. So we're including it here on the manufactured home and floating home sale agreement. So we are asking the agents to put in their license number through OREA, as well as to put in the DCBS license number that they have. If this is a manufactured home in a park sale, they will need that DCBS license number. Okay, so there may be additional fields here that aren't being filled out because, for example, if the firm or the principal broker has the license, but the individual agent doing this transaction does not, there wouldn't be a number to fill in here. There would just be a number to fill in here. But we did want to provide all of these fields so that they can be filled in. And as I mentioned, even though the OREA license number wouldn't really be required, we want to see it there. We put it there because we think it's helpful, and that does allow your client to identify you or look you up, look up your history if they want to do that. We think that's helpful consumer protection. Otherwise, I'm not really going to talk in detail about this final agency acknowledgement. Those of you who've taken any of our other trainings on our residential or other agreements will have already been trained on how we've set up our final agency acknowledgement, including the fact that we here on our final agency acknowledgement, as well as on all of our documents, have a place for 4 buyers and 4 sellers to be signing the document. Okay, and up above, we have a place for 3 agents to be identified on behalf of buyer and 3 agents to be identified on behalf of seller, in case you're working with teams or doing some sort of co-listing arrangement. Now we're getting to the main document here, and similar to our residential sale agreement, we open up here with an introductory clause. And the first thing that this does is explain the use of this document. Okay, so we are saying that that this document is for use with manufactured and floating homes with existing tenancies or own spaces or slips in a marina or manufactured home park. Okay, it is not for use selling a manufactured home that is owned by the same person who owns the land underneath and is affixed to that property. That is going to be a real property transaction, in which case you'd be using our residential purchase and sale agreement. We inform the parties that this is a legal document, that they need to seek competent legal counsel and financial advice should they need that. We also here, as we do in our residential agreement, have a place for the buyer and seller to indicate that they have read or they've received and understand, read and understand our Oregon Realtors buyer and seller advisories. Okay, so those are in your forms library as form 10.1 and 10.2. They're also available on our website in a version that's a little bit shorter. We shrunk the font size and we removed the requirement for initials on every page of the document. So if you're looking for sort of a more streamlined version of that document, you can find it on our website, but you do need to provide it to your clients. We recognize that there may be many items in the buyer and seller advisories that are really more relevant to a real property transaction. Okay. However, there are items in there that are also relevant to a manufactured home in a park or a floating home transaction. And we think it's important that your buyers receive those documents, they read through them, and they understand them, because that's going to help your buyers and sellers know if they have additional questions that they want to ask, because there's a lot of important baseline information in there. So then, of course, we're going to fill out the names of the parties. Parties are agreeing to purchase and sell. Section 4 here is where we're going to describe the property. Okay, so this is going to be different than what we have in our residential purchase and sale agreement. You're going to indicate whether it's a manufactured dwelling or a floating home. You're going to put in the address of either the manufactured home park or the marina. Okay, the manufactured home park space number or the slip number if it's a marina, the county, okay, and then the manufacturer and the registration number and the serial number, okay, of that home, okay, whether it's the manufactured home or the floating home. Then we're going to indicate whether the space is owned or leased. Okay, now in most cases it's going to be leased. If it's owned, as in it's a manufactured home and the seller owns the entire land underneath, you're not even going to be using this form. You're going to be using our residential. However, in some instances, the actual park is owned by the tenants of the park. And in that case, or the marina is owned by the tenants of the marina. In that case, you would use our form 4.4. Our form 4.4 is our association addendum. Okay, and so that's what's used often with homeowners associations, but also can be used here for a manufactured home park that's owned by the tenants of the park, or a marina park that is owned by the tenants. And that's going to give the buyer the right to receive all the documents related to that ownership association and have a contingency to terminate the transaction should anything that they learn from those documents, or if they don't receive the documents, but anything they learn from those documents, they would that makes them not want to move forward, they would be able to terminate the transaction. Okay. Now, assuming it's leased, we're going to indicate the landlord, the owner of that manufactured home park who is running that park, or the marina, and then the phone number and email information there. And that's going to be important. The buyer in this situation is going to be having to do some direct communication with the landlord of the park or the marina, and having to apply to be approved to be a tenant there. So they're going to need that direct contact information. The next section is on our financial terms. And so here there's going to be a purchase price, earnest money amount, remainder of down payment, remainder of purchase price, any closing costs or prepaid items paid by seller. And if any of these amounts are going to be contingent or non-liquid funds, that needs to be specified. So if that cash is not currently available, if you have to liquidate an account, or you're expecting a bonus, or you're expecting a gift, that all needs to be identified because the seller needs to know that in evaluating the quality of your offer. If seller carried financing is going to be used, you would check that box there, and Form 8.1 is our seller carried finance addendum that you would use. Now, Section 8 here, this is one we recognize could be improved from the perspective of a manufactured home park or transaction or a floating home transaction. Several of these loan types would not be available if for a buyer purchasing a manufactured home in a park or for a buyer purchasing a floating home in a marina. Okay, so but the good news is we have the other box. Okay, so there may be a chattel's loan or a personal property loan or maybe even home equity is being used. But if it's something other than what's available here, for you to check a box, just use the other box to specify the type of loan that is going to be used if there is a loan that will be used. Okay, and then of course, evidence of pre-approval for that loan is required. You can attach it here if it's available. Later in the contract, there's a deadline pre-printed of 2 business days for that to happen if it didn't happen with the offer. We're going to identify the closing date and possession date if it's different. You can use our occupancy agreements, Form 2.16 and 2.17, if there's going to be a occupancy agreement to occupy before closing or after closing. Again, here we recognize that many manufactured home parks, okay, and probably many or perhaps marina parks as well, would have rules related to whether or not a pre or post closing occupancy is even allowed. Okay, and so you need to look into those rules, but in some cases it would be allowed, and so we have the fields here for that, and the forms are available for you. Indicate whether prorations will occur as of closing, possession, or some other date. Okay, identify the escrow agent company and the officer. Now, not all title and escrow companies do manufactured homes and parks. Not all title and escrow companies do floating homes in marinas, but we would recommend that you find one that does. Okay, some people do these deals without using a title and escrow company. We really don't recommend that. We would suggest find a company that does do these, and if you are starting to do more and more of these, you know, find someone that does them well, and that you're comfortable working with. Okay, included items. So here, now of course, the structures themselves in this case are personal property. Okay, this is not real property, but we've already identified that personal property up here. So here's where you would indicate if there is additional personal property that's going to go along with the sale. Okay, so if there are items in the home that you want to include, you would indicate that here. Now we recognize again that we're working off of our, we kind of riffed off our residential sale agreement where we're talking about fixtures as fixtures being something attached to the real property, whereas here what we really are intending to mean is items that are attached to the structure. Okay, so I think again, as we go forward and update this document, we may start using some different language there. Because we're not talking about real property, and typically fixture is a term that we use with real property. Okay. Now, new construction. Again, this is a section where this may or may not end up applying in your situation. So if it were a new floating home, okay, that floating home would have had to been constructed by someone who is a licensed contractor, okay, in which case checking yes and using our new construction addendum actually would make a lot of sense and would provide protections for the buyer, against liens, but also in getting more information on that contractor and creating some opportunities for that buyer to have some remedies against that contractor. Okay, so I would encourage you to look at the Form 4.1, the new construction addendum. There may be some provisions in there that really don't apply, but the general form is going to be helpful for you in the case of the floating home because it's constructed by a contractor if it's new. And so you're going to need to read that form. If there were sections that didn't apply, there is an additional provision section that you could use, okay, to identify those that the parties don't want to apply. Now, if we're talking about a manufactured home that was built in a factory that's new, that's an instance where our new construction document really is not going to be applicable, okay, because that home was built in a factory, not by a licensed contractor. And that new construction form 4.1, is really all about the issues that come up related to contractors. So you can use it. I mean, you could pull it up, see if it has some good things in there that would help protect your buyer that you want to use. But I'm just kind of forewarning you that the Form 4.1 was really designed more with real construction of real property on site in mind. But as I mentioned, it actually would work quite well, I think, for the floating home situation as well. Now, are there tenants in the property currently? Yes or no? And then we have an investment property, we have a tenant vacancy addendum if the buyer is going to be moving in as a primary resident and the seller is going to have to issue a termination notice to the tenant. And we have an investment property addendum if the property is being purchased as an investment property. So again, depending upon the rules of the park or the marina and all of that, and some of these situations may not apply, but it's always is going to be a material fact to know whether there is or is not a tenant in the property. And then these other situations, may or may not apply. Okay, if the seller is supposed to terminate the tenancy, you check yes, use Form 7.1. If they're not supposed to terminate the tenancy, you check no, you use Form 4.2, investment property addendum. So I think those will always be helpful to you. So that is an instance where I think this will line up well in the manufactured home or the floating home situation. Now, association, we already mentioned this. If the property is in a manufactured home tenants association or a marina tenants association, then you check yes, use our Form 4.4 association addendum. Okay, so we already know that it's likely that in most cases somebody else is going to own the park, somebody else is going to own the marina. But in those few cases where it's a cooperative ownership among the tenants of the park or the marina, that's where this comes in, and you use the Form 4.4. Okay, are there contingencies associated with the sale? Is the buyer making the deal contingent upon selling their other property? Is the seller making the deal contingent upon finding a replacement property? If so, check the appropriate box and use the appropriate Form 2.10 or 2.12. Okay, water and sewer connections. Now, in most cases, if you're not going to have like a private well situation here, okay? But so the property itself may be connected to public water and sewer, or likely, talk about a manufactured home in a park here, likely the park is going to have the water and sewage source. It may be public. It could be a well that's operated, as a, for multiple people and an entity that manages the operation of the well. Okay, so check the box that best applies. If one of these boxes you feel like does not apply, you can always check other source and specify. Okay, now the advantage, like let's say for example, that there is a well. Okay, if you check the box for community well and you use that well addendum is going to provide a contingency period for the buyer to check out the well, do inspections, and terminate based on it. Okay, so there are helpful protections there, but at the same time, it may not be that the buyer is going to be able to have direct access to testing the well. They might be able to test at the tap, of course, but they wouldn't necessarily be able to directly test the well if it's a well that is sort of operated under a separate agreement for multiple people. It may be that there would be documentation related to the quality of the water for that well, and there'd be reporting that's required. Okay, so in some instances, it may make the most sense to check this box and say that, hey, it's provided by the park. Okay, and then your buyer is going to have the opportunity to review all of that when they get the park information. Okay, as well as they have their due diligence period. But if you find that you think that the well addendum itself is helpful, you could check the community well box, for example, and use the well addendum. So you're going to kind of have to just get a little bit more information about what the particular setup is there. But it's always going to be okay to check this box and say that it's provided through the park, and then the buyer is going to have the opportunity to review all of the documentation from the park, as well as they have their main due diligence period. Now, lead hazard. So this is going to apply to manufactured homes. If the manufactured home was constructed before January 1st, 1978, then you are going to use the lead-based paint addendum, and you're going to also provide the EPA provided pamphlet for the lead-based paint and lead-based paint hazards. For floating homes, that law does not apply. However, if there were a situation where the floating home was built before 1978, and you wanted extra protection for the parties related to lead-based paint, you could go ahead and use that documentation anyways as an extra layer of protection. But the federal law does not require that be used in a floating home situation. Wood stove laws, okay, you're going to want to comply with those. If there is a wood stove, check yes and use the form that goes with that. If there's any leased or financed equipment like solar panels or alarm systems, then you check the box here and use our form 7.3. I don't know sort of what the situation is with the home warranty companies and what coverage, if any, they do. I imagine that they do coverage on manufactured homes. I don't know what they do related to floating homes, but if there is a warranty, then you need to fill out the information here in this section. If not, just check no. We do have additional provisions here. There's not a lot of space, but we have a general addendum form 2.2 where you can add even more provisions. If you're using zip or skyslope and you have a field like this with multiple lines and you type and you get to the end of it, it should auto populate that form 2.2 general addendum. And so if you're not using zip or skyslope, that won't be there, but it should be functioning such that it'll automatically grab that addendum for you. Now, again, if you've taken our trainings on our other documents, I think you'll know how much of this works in our counting time provisions, but I'll just go over it quickly. These are the time period provisions of our document now. We've moved on from the sort of specific unique provisions related to the property and the parties. Now, on the counting time, most things that we do in here are going to be in business days, okay? Unless we say otherwise, the beginning of the time frame, the triggering event that triggers the time frame is going to be mutual acceptance of the agreement. In some cases, it may be something else like delivery of a notice. Okay, the first day that's counted is going to be the day following that triggering event. Okay, so for most things, it's going to be the day following mutual acceptance. If it's a business day timeline, it's going to be the business day following mutual acceptance. Calendar day timeline, it would be the calendar day following mutual acceptance. Again, almost everything's gonna be business days other than the lead-based paint stuff. Also, our late acceptance addendum that we have when a party's trying to accept the offer after the offer expiration deadline, that form also uses a calendar day. Specific dates control. So again, if you've taken our classes, you know this, but you need to check the box affirmatively. If you want it to be 3 business days, you should check 3 business days. If you want it other than 3, you check here and put it in here, okay? As with our other agreements, we have set up the earnest money deposit deadline. Here you can pick a date, but then we've laid out the process for what happens if the buyer does not deposit the earnest money by the deadline. Okay, so the seller is going to have 2 options. Okay, I'll read the second one first here. If the buyer does not provide the earnest money by the deadline, then the seller within 2 business days after the end of that deadline can just terminate the transaction. They deliver a notice of termination to the buyer. Earnest money, if the buyer had paid partial earnest money, okay, it would be refunded to the buyer. This is essentially, we're terminating, no obligations to each other, everybody's moving on, and we're just agreeing to move on, no harm, no foul. And that's one option that the seller can take. The other option is that the seller can provide our notice of default to the buyer. And tell them, buyer, you were supposed to deliver the earnest money by this date. You didn't do it. I'm giving you 3 or 4 or however many you want to put in there business days to do it. And if you don't do it by then, not only will I have a right to terminate, but I'll also have a right to that earnest money. So if in that instance, the seller could terminate the transaction if the buyer did not comply by that second deadline, and then could file a small claim or in arbitration mediation, depending on the amount in controversy to actually get that money out of the buyer. Okay, so seller gives a little more time to buyer, buyer's going to have a little more skin in the game. Buyer representations and duties regarding financing. I won't go into too much depth here. So you can read this on your own. It's, I believe, the same provision as we have in our residential sale agreement. One of the things that I will note, though, is that if there's going to be an appraisal, okay, then we say that by the business day following the end of the due diligence period is the option you can check here, okay? And then if you don't want that to be the case, you could check here and pick a number of business days, okay? But the pre-printed option here is the business day following the end of the due diligence period is when the appraisal would need to be ordered. Our financing contingency section, this is going to be the same as it is in our residential sale agreement. Well, there are two financing contingencies that the buyer and the property qualify for the agreed upon loan. Okay, so that's the type of loan that was identified on page 1. Okay, and also that the appraisal is equal to or greater than the purchase price. Okay, if the parties wanted to modify or waive that appraisal contingency, we have a separate document, form 2.14. I believe it's 2.14. That is our waiver or modification of contingencies document. And you could use it for that purpose if that's what your client wanted to do. We don't encourage waiver of or modification of appraisal contingency, but we know that that does happen sometimes. Then the way this would work is that the buyer would have to notify the seller if their financing contingency failed. Okay, we get to pick here up front how many days you have for that. We know maybe buyer gets noticed that their financing contingencies failed. They still want to move forward, but they need a little bit of time to sort of get their information in order or talk to some other lenders to figure out what they're going to be able to do. So it could be advantageous to your buyers here to, give them a few days. Okay, so we thought it was helpful to actually give you an option on that. And then what would happen next is the buyer would be able to terminate. Okay, when they provide the notice that the financing contingency failed, they could terminate at that time by sending a termination notice. Or if they don't terminate at that time, the parties are going to enter a renegotiation period. The pre-printed time for that is 2 business days, but they can fill in what they want here. And then they are going to attempt to renegotiate. If they do renegotiate, then they would be filling out an addendum that would be memorializing that renegotiation with the new terms of the contract, okay? But if they don't do that, if they don't come to a written agreement about a renegotiation, then we give the parties 2 business days after the end of that failed financing renegotiation period to terminate the transaction. We give either buyer or seller the right to do that. Okay, either one can do it, and all they have to do is send the termination notice. If that happens, then buyer is going to be able to get their earnest money back, and everyone's going to be able to move on. Okay, if nobody does that within 2 business days of the end of the financing renegotiation period, the deal is going to be presumed approved without the financing contingency. So buyer's agents, you just need to pay attention to this. It's not an automatic termination like it is in the ORF agreement. So be sure that you do send that termination notice. You have ample opportunities to do it, but I just wanted to highlight that for you. Proof of funds for cash purchases. This is the same provision as in our residential sale agreement. Buyer has to provide proof. It has to be reasonably satisfactory to the seller, and there's a time period here you can select for that proof to be provided. Okay. Now, this is a provision, section 28, our rental document contingency. This is specific to this agreement. Whether we're talking about manufactured home in a park or we're talking about leased mortgage space in a marina, there will be rental documents. And so there needs to be an opportunity for the buyer to receive those documents, to review those documents, and make sure that they are comfortable with the marina park rules and the rental agreement for the manufactured home park or the marina park, the policies of those parks, okay? As well as the applicable rules for screening and acceptance of a purchaser, because as I mentioned before, the manufactured home park and the marina park are going to have to approve the buyer as a tenant, and the buyer is going to have to submit an application. So the buyer needs to know what are the rules around that, what are the approval rules. That needs to be provided here by the seller as part of the documents that the seller provides for the buyer to review. Buyer is going to have a 10 business day if you go with that option, or whatever you put in here, period, to review these rental documents. Okay. if anything in those rental documents makes the buyer want to renegotiate aspects of the deal, then great, they can propose that and try to get the seller to agree. Okay, but if you know, ultimately, if the buyer wants out, they're going to have to terminate within that period of time if they're terminating based upon this rental document contingency. And they can do that by delivering the Form 5.3 notice of termination. Okay, we have our due diligence contingency provision here. This is going to be very similar to the provision in the residential sale agreement. They were informing the buyer to do all due diligence related to the property. Okay, so not just an inspection, certainly an inspection. Okay, but any other diligence that they want to do on the property to assure that it meets their needs and that it's economically feasible for them. If for some reason during this period they determine that this property is not economically feasible for them or it does not meet their needs, they will be able to terminate during this due diligence contingency period. The way to do that is you take our buyer's termination notice to seller and check the box that says buyer is terminating during I can't remember the exact language, but buyer is terminating during or based upon the due diligence contingency. Okay, just check that box and you send it. If you do that within the amount of time given here, then the buyer is going to get their earnest money back. Okay, as I mentioned before, there are different types of inspections that your buyer is going to want to do for these types of properties than perhaps they would be doing for a residential real property. With the manufactured home, there are specific issues that come up related to the foundations and the impact on the structure of the foundation. And so your buyer's going to want to find somebody who has done those types of inspections and is familiar with that. Okay, whether it's a single inspector who has that type of expertise, or it's a second inspector on top of the one that's doing the rest of the property. With the floating home, the buyer is going to want to do a float inspection. Okay, I cannot tell you where to find float inspectors. I'm sure if you Google, you can figure that out, but your buyer is going to want to make sure that they are getting the types of inspections they need for this particular property. The other provisions of this section are very similar to our residential sale agreement. Of course, buyer is going to be responsible for restoration of the property following any inspections. We do define several inspections as non-invasive so that a buyer could do them without getting special permission from seller. We do say the float inspection, okay? So that's unique to this document. But then mold tests, pest inspections, dry rot inspections, sewer scopes, radon tests, those are all included in our residential agreement as well. Okay, those are all, you can do those without additional permission from seller. And then we added here structural inspection. Okay, so as I mentioned, that foundational inspection, you know, probably would be covered anyways. I mean, arguably wouldn't be considered invasive, but here we just wanted to specifically define it as non-invasive so that buyers know that they can do that without any special permission. Then rest of this, again, very similar. Buyer would need to terminate within this time frame if they want to do it based upon this contingency. Of course, seller's not going to be required to make repairs, but if they don't, buyer may terminate the transaction. If the parties agree to a repair addendum or they agree to a general addendum that modifies the payment terms in lieu of repairs, okay, that's going to be considered an end of the due diligence period. Okay, they've identified issues and they've come to an agreement on how to resolve those issues. There's not going to be a second bite at the apple then for the buyer to come back and bring up additional issues related to the due diligence contingency. Okay, and then finally, I will point out, as with our residential agreement, and we know that this is controversial in the industry, but we like the way that we have set this up, is that the buyer is not prevented in our document from sending an inspection report to the seller if the seller didn't ask for it. Okay, so we're not saying that they should send it or anything. We don't say anything about it. So if they do end up sending a report to the seller, and the seller didn't ask for it, that's not going to be a breach of the contract by the buyer. However, we do specifically say that if the seller requests it, the buyer must provide it. Okay, so if the seller asks for that, any inspection report, buyer needs to provide it. That obligation remains for up to 10 business days after a termination. Okay, we have a section on smoke and CO detectors here. That's really important. Make sure that those are installed. If there was an appraisal and the smoke and CO detectors were not installed prior to appraisal, then we have a provision here that says the seller is going to be the one financially responsible for the cost of any reinspection that's needed, because the appraiser and or the lender are going to want to know that those smoke detectors and CO detectors are installed. We do have a risk of loss provision, which actually becomes more relevant in this document than in our residential document. The reason being, there's already a statute in Oregon law that governs what would happen in a real property transaction when all or a material part of the property is destroyed during the pendency of the sale agreement. There is not a similar statute related to these personal property transactions of a manufactured home and a park or the floating home. And so our risk of loss provision becomes more important here even. And the basic idea of this provision is that if neither closing nor possession have occurred, okay, the buyer is not going to be obligated to purchase the property if all or a material part of it was destroyed during the period of the contract, okay? And they could issue a termination notice to the seller saying, I want out, and they would be refunded all earnest money and any other deposits that they paid, okay? However, if a buyer wants to still move forward, okay, we're giving the buyer the option to do that, and they can provide notice to the seller that they want to do that. The seller is going to be obligated to diligently pursue their insurance claims and the repairs that are required. The contract would automatically extend for up to 60 days to give the parties time to get the property repaired. Okay. At the end of the day, if the property wasn't repaired and in the condition that it was in when buyer made offer, then buyer's not going to be obligated to move forward. But we did want to give an option here for a buyer who says, yeah, part of this property was destroyed, but I think it can get fixed. I still want to buy this property. And so that's what we have here. In most cases, a buyer is just going to probably back out, and they have a right to do that. The important thing to know, though, too, is that if all or material part of the property was destroyed in either closing, which is obvious, but possession have occurred, the buyer is going to be obligated. Okay. So that's a risk of a buyer's agreement to occupy before closing, is that if they're in possession of the property and it gets destroyed, they're still going to be obligated to purchase. Okay. Now we have our lead-based hazards information here. As I mentioned, the lead-based paint laws for the federal government apply for manufactured homes. Okay, whether they're in parks or whether they're on real property. For the floating homes, they don't apply, but there could be situations where there is lead-based paint in the floating home, and so your parties still could use these documents. Okay, and if you're a buyer, probably a good risk management thing to do that. Okay, so we'd encourage you to actually use these in any case where the property was constructed prior to 1978 or within the vicinity of that, because could be that it took a while to construct the property and it began before January 1st, 1978. Okay, application acceptance. This next provision here is again specific to this agreement, and it is saying that the buyer is going to have an obligation to request an application for tenancy in the manufactured home park or the marina park. Okay, so promptly, and our contract is defined. It means as soon as practicable and never more than 2 business days. So you got to get on that. Once you get a signed agreement, buyer needs to, as soon as they possibly can, and certainly never more than 2 business days, but really as soon as it's practical for them, they need to be able to go and request that application. Okay, and they should start filling it out. If the landlord has not approved the buyer's application before closing, then the parties can choose to extend the closing date. Okay, that's a choice if they want to. But if they don't do that or they can't agree on that, then either party can terminate. Okay, and the buyer is going to get their earnest money back. Because if the buyer's not approved to be able to be a tenant in the park, then they're probably not going to want the home, and this is not a deal that really should go forward. Okay, assignment of slip or space. So I don't think this is really going to apply, because this document is going to be used when either the seller does not own the space or the slip, or if they do own it, they don't own it outright. They own it as a cooperative ownership association of the entire park. Okay, So here, I don't think there's going to be many situations where you would need to use this assignment clause, okay? Because if it's a manufactured home that's, I just don't think it comes up a lot where that specific space is owned, okay? But if that were to be the case, then this assignment clause would apply. Now the ownership documents, okay? So the titling works a little bit differently for the manufactured homes and for the floating homes, and both work differently, of course, than they do for real property. So if the agreement relates to the manufactured home, then the parties need to complete the form 2952. That is the manufactured home application form, okay? We do provide a link to the website where you can get these documents. Depending on the details of that home, there may be additional documents that are required by the Oregon Department of Consumer and Business Services to transfer ownership. Okay, again, that information is going to be available on this website. Okay, and then another thing that's going to always be required is a county tax certificate. Okay, and so the county is taxing that personal property, and so you need to work with the county to get that tax certificate. Now, if you're working with a title and escrow company that's familiar with this, then hopefully they're able to do most of this, okay? But as I mentioned, some are more or less familiar with it. It would be good to find companies that you can work with that are very familiar with this. So we say that we have this provision here says that escrow is not involved in the transaction, but the seller needs to file all of these completed documents and the county tax certificate at seller's expense within 30 calendar days of closing. I really, really, really strongly encourage you not to do these deals without title and escrow. Find a title and escrow company that's familiar, have them do this piece, but be familiar up front. Make sure you know which of these pieces that they're able to do. Okay, so talk to them ahead of time, because if there's anything that they say, we don't do that, the parties are going to need to do that. You want to know that up front so that that everyone is aware and is able to take care of it. Okay, now with the floating home ownership documents, okay, we say that the parties need to execute the transfer of title at closing, and the seller needs to sign the release signatures on the floating property's title, and the buyer needs to complete the application for floating property that's located on the back of the title document. Okay, so if there's a title document, that application should be located on the back of it. Okay, if it's not, that application document is available from the Oregon Marine Board. The Oregon Marine Board also has a website that has information and explanations and documents related to titling a floating home. So I encourage you to go to that website, check it out, get familiar with it, and make sure that the parties that you're working with are familiar with that as well. We have the same provision down here that says that if escrow is not involved, then the parties need to the parties need to deal with it, and the seller will have to submit the signed title documents at seller's expense to the Oregon Marine Board in this case within 30 calendar days after closing. I think there are quite a bit fewer title and escrow companies that do any floating home transactions than would do manufactured home in a park. So hopefully you can find a title and escrow company that will do it. It could be that in the floating home situation, that is one where parties are going to have to handle some of this on their own. We have the seller property disclosure statement. This is going to apply only to the manufactured homes. Okay, and again, it's really under the law. Okay, this law only applies if the seller owns the land underneath the manufactured dwelling. Okay, so the legal requirement to do the SPDS would if the seller owns the land outright, in which case you wouldn't even be using this agreement. If it's that type of cooperative ownership that I'm talking about, where the tenants own the manufactured home park, I don't think it's entirely clear if the seller property disclosure statement would apply in that situation. Probably a good idea to include it because I think it's a little ambiguous. In most cases here, though, it's going to be a leased space, in which case the seller property disclosure law is not going to apply. Now, that doesn't mean you can't still use it, okay? It still would be helpful. And so we would encourage the parties to still use a seller property disclosure statement, but it's not going to be required by statute. And we do not in our library have a separate disclosure document for manufactured homes. Okay, so we have our residential one, we have the vacant land one, we have an agricultural land one. We do not have a specific one for the manufactured home. We do not have one for floating home. Okay, new construction, I already mentioned this before. This is, it might be a little clunky in these situations. For the floating home situation, it probably is going to work decently well because a contractor will have built that home if it's a new home or a new floating home. In the manufactured home situation, it's going to be built in a factory, and most of that document is going to be dealing with contractor issues, and it's not going to really be applicable in your situation. So we have our definitions next. This is now the general terms section of our document. Definitions are going to be quite familiar to you if you've looked at our other documents. I'm not going to go through them in detail here. Okay, we do have an additional seller representation section. So even though the seller property disclosure statement's likely not going to be required, the seller is still making representations about the condition of the property and legal facts related to the property, and that the property does not have material defects that they are aware of. Okay, so this is a really important part of the contract, particularly in this contract, because there might not also be a seller property disclosure statement that's already going to be covering those things. So your sellers need to read this and make sure that these are true statements. If these are not true statements, the seller should not be agreeing to this. Okay, they would need to disclose and identify to the buyer what is not true here, and the buyer would need the benefit of that information before they enter into a contract with the seller. Okay, of course, though, the buyer is going to have had their opportunity to inspect, and they're going to have had the opportunity to review those disclosures by seller, or these statements here, if true, by seller. And so when the buyer does end up buying the property, they've benefited from those representations. They've benefited from the opportunity to inspect. So they're going to be buying the property as is, where is. At that point, it really is buyer beware. The only instance where a buyer was going to have a remedy after closing in that situation is if the seller had misrepresented something to them. Okay. We have a section on proration of taxes, fees, utilities, rents, deposits. It's same language that we include in our residential sale agreement. We have the same for closing costs, allocate those between buyer and seller. If there did need to be an amendment to how these allocations are laid out in either of these sections, you could use the additional provisions section or in a general addendum to accomplish that. Okay, we have our closing and possession section. Again, it's very similar to our residential sale agreement. Closing is going to occur on the date identified on page 1 of the agreement or earlier if the parties agree to earlier. Unless otherwise agreed in writing, closing and possession will occur by 5 p.m. on the closing date. Okay, we don't think that weeks or months in advance of a closing, it makes sense to pick a particular time. So we're saying it should occur by 5 p.m. Okay, and if the title and escrow company can get you in at 3 p.m. for the signing or 11 a.m. or whatever it is, that's fine. We don't think that the contract should be in that level of detail. Of course, if the parties want more detail, they could write it in on additional provisions or in an addendum. Then seller is going to have to deliver the property and its components in substantially the same condition as when buyer made their offer, and they are going to have to repair or replace any systems or appliances that become inoperative or that malfunction. They are going to clean, and they are going to remove all trash and debris. Okay, and we say that unless otherwise agreed, the seller needs to remove all personal property that's not part of the transaction. If they leave personal property that was not identified to be part of the transaction, they're going to have no rights to come back and get it. Okay, the buyer could sell it. The buyer could call 1-800-GOT-JUNK. If the buyer has to expend a resource to get rid of it, our contract gives the buyer a right to recover those costs from seller. The only caution I would give buyers on this is if it were a custom piece of artwork or a mural, there may be rights that the artist has in that property, in that art. Okay, so you're not going to want to destroy it until you've investigated whether the artist, him or herself, may have rights in that. Okay, but the seller is going to have no more rights in it. The next section here is about default. This is where we describe how to use our default documents. Okay. And preparing for this presentation, we recognize that there's an errant sentence right here that got in there somehow or another from our dispute resolution section. That will be removed, but for now, please, ignore line 321. Okay, but the rest of this section is going to talk about default. We have a document called the buyer's notice of default to seller. We have another one, seller's notice of default to buyer. That document is used to inform the other party they have not complied with the term of the transaction, give them a period of time to come in compliance, and tell them if you don't come in compliance, I, the one who sent you this document, has a right to terminate and has a right to the earnest money. Okay, we've built that into our contracts as a way both to help keep the parties on track, but also make it clear when termination is appropriate and who gets the earnest money in the event the termination occurs because one party was not fulfilling an obligation to the contract. Hopefully those are helpful for you. We have a training specifically on our defaults and terminations, so I won't go into much more detail on that here. The one thing to note though, there are some instances where you won't need to send that notice of default in order to terminate, okay? If the party has, down here on line 332, if a party has misrepresented a material fact about related to the subject matter of the contract, that's not curable. That would give reason for the other party to terminate, okay, without having done the notice of default, and the buyer would be able to, if it was the buyer terminating, they'd be able to keep their earnest money, okay? Party wrongfully fails to close or perform an obligation required to close by the closing date. If you get to the closing date and one party can't fulfill their obligation to either deliver title to the property or deliver the money, then you don't have to issue a notice of default. The other party can just terminate. And if it was the buyer, they'd have a right to keep their earnest money. Or if a party failed to meet an obligation under this agreement and the language of the agreement expressly permits the other party to terminate using our termination notice without first sending the notice of default. There are going to be some provisions in the contract itself. It says, hey, if seller does this, buyer can then just do this, okay? Or if buyer does this, seller can just do this. If it says you can just send a termination notice, then great, you can just send a termination notice. No need to use the notice of default. The next section is about termination and escrow instructions. So again, we have a whole training on termination, so I'm not going to go into it here. The only high level thing I'll point out is our terminations. We have a separate buyer's notice to seller and seller's notice to buyer. All of the reasons for termination in the contract and any addendum to the contract are listed there, so you can just check the box of the one that applies. Okay, you send that to the other party. If you're a buyer, you send it to the seller. You also send it to escrow. The party receiving the termination notice has 2 business days to reply on their response to termination. They send that to the other party and they send it to escrow. At the bottom of both those documents are a place for each party to put their escrow instructions. If the escrow instructions match, then escrow is going to deliver the earnest money to the party which has been identified. If they don't match, then the parties are going to be going to dispute resolution, presumably. Okay. We have a section here just about earnest money. I won't go through that. I think we've that's really covered heavily in the termination pieces and throughout the contract. Our dispute resolution provisions are the same here as they are in our other agreements. It is small claims court if it's within jurisdiction of small claims, that's $10,000 or less. If it is a non-monetary dispute or it is a monetary dispute for more than $10,000, that is going to be mediation and then arbitration. The mediation and the arbitration are going to be filed at Arbitration Services of Portland unless the agent is a member of PMAR. If the agent is a member of PMAR, then the parties would file the mediation through PMAR because PMAR offers a buyer and seller mediation program. Okay. Now, I don't know if the PMAR buyer and seller mediation program has any special rules about whether they do manufactured home and park or floating home transactions. So that would be something to take a look at. The rest of this, these are kind of general contractual provisions. Assignment. Parties cannot assign unless there's permission from seller. That can happen in one of 2 ways. There could be a specific permission from seller saying you can assign the contract, or you can assign the contract to X, Y, or Z. Or if the buyer writes that their name up top where they identify themselves as buyer and or assigns, and the seller agrees to the agreement, the seller is going to be agreeing to allow the buyer to assign the contract. The obligations are going to survive the death of the party, so the heirs and estates are going to be obligated to follow through on the agreement. Time is of the essence, so missing a deadline is important, and it's a material default. Okay, and then the severability, meaning that if any portion of this agreement were to be, thrown out by a court or deemed not to apply, the rest of the agreement would still apply. I just want to go back real quick on the time of the essence. I know I mentioned that everything's material, and I mentioned material default. So that is true, but of course, it's also subject to our default process. So just be sure that you are using our notice of default when it's appropriate to do so. Non-waiver means that, hey, if a party sort of let the other party get away with something during, that party didn't meet an obligation, but the other party said, I'm gonna let that slip this time. It doesn't mean that that party is letting them get away with doing that again in the future, or not complying with other terms of the agreement. Okay. This is the entire agreement. You need to put it all in writing here. If you're going to modify it, you need to use an addendum in writing to modify it. Anything that you talked about before is not going to be part of this. If it's just in the MLS, it's not going to be a part of this. Counterparts, that means that if for some reason your parties can't sign the same document, which rarely happens now with DocuSign and DigiSign and all of that, but if for some reason they needed to sign identical versions of the document, but they were separate, that's okay. If they both signed it and they were identical, it would come together and form a contract. The buyer is going to indicate offer deadline here and then sign date and time. The seller is going to have an opportunity to either accept, reject, or counter. 2.1 is our counter offer form. If the seller is trying to accept after the offer deadline, they would use our 2.3, which is our late acceptance addendum. That then puts the power back in the hands of the buyer. So the seller signs this, so they would check accepts. They would sign here, date and time, and they would then also sign the late acceptance addendum. They'd send both back to the buyer. And then the buyer is going to have the power to sign that late acceptance addendum should they choose to move forward. The buyer doesn't want to move forward, they don't have to, and they don't have to sign that late acceptance addendum. Buyer has 1 calendar day to sign the late acceptance addendum after it's been delivered. Okay, and then here we have a place for the agents to indicate that they have presented the offer to the client, so you can have that for your record. This is for the listing agent presenting it to their seller. The other thing to note is this agreement is not an earnest money receipt. Okay, an earnest money receipt has to say whether it was by cash or check or promissory note. This document doesn't talk about that. We presume that earnest money is going directly to escrow. If you are taking earnest money, you need to have your own separate receipt for that. Okay, so that is the presentation today on the manufactured home agreement. As I mentioned before, we recognize there are some pieces of this agreement that probably could be streamlined to be more specific to manufactured home and floating home and not for residential. And so we are going to work on that, and we're going to be convening experts in manufactured and floating home sales so that we can make sure that we make updates that are appropriate. And then let me see if there are any questions. Nope. All right. Well, sorry that we went over a little bit today, but be sure that you will get, well, you're not on anymore, but everyone will get their CE credit if they stayed on for the amount of time required to get CE credit. So thanks everyone for being here, and we look forward to seeing you next time.